Hello friends, in this video I'm going to explain about the amendments and the basic structure. Significant provisions will automatically come. Okay, what are the all the provisions our constitution gives to us, it will automatically come. Okay, by then let's begin this class. We will just start the amendments first and then we'll go to basic structure. Actually, after basic structure only this amendment should go on, but it is comfortable to first say the basic amendments and then the basic structure. Okay, so before starting the lecture, as usual, I will say a few words which I hope might inspire you and might be helpful for you in some or the other part of the life. So in relationships, don't force anyone to stay. Okay, if they want to go, just let them go. Don't force them, or if you force also, it will not work out. Okay, it is safe for you and it is safe for them also. Let me tell you a story. Okay, and that Radha asks Krishna, who is the god of gods, to him Radha asks, like, hey Krishna, I am the most loved by you, then why won't you marry me and set an example? Then Krishna replied, like, some relationships are made for love. In future also, most of the relationships will come near the love, but the marriages won't happen. Most of the relationships, they end up without getting married. So for such relationships, there should be an example, right? So I'm setting example as our couple who did not marry but who loved one another unconditionally. So in this way, Krishna replied to Radha. So most of the relationships, they just don't travel till the marriage. Okay, I don't know why this dog's here. There's a problem near my area. Just adjust. Okay, so most of the relationships don't travel till marriage, they end up till love only. It is fine. Okay, and if they really leave you, if they really change, then you have to change yourself in such a way that you just start changing yourself, then automatically everything will be on track. There will be wondered how he has or how one got changed. Okay, so with this note, let's start the amendment class. Okay, amendment, as the word suggests, it is the change. Okay, every constitution needs to change according to its needs. Some constitutions have evolved long back, and the same situation does not prevail till today. So for today's new needs, the constitution also needs to be amended. So there is a law called Article 368 in the Indian Constitution itself, which allows the Parliament to make changes according to the needs. It is Part 20 of the Constitution. Okay, so Article 368 and Part 20 of the Constitution deals with the amendment of the Constitution, and you can amend anything in the Constitution regardless of the basic structure. In Keshwananda Bharati case of 1973, here it is. Okay, 1973 Keshwananda Bharati case. That is why I told you after basic structure only amendments will be explained, but yet I will explain it later there. Okay, what happened in the Keshwananda Bharati case of 1973. After that, without amending the basic structure of the Constitution, basic structure of the Constitution being constant, you can amend anything in the Constitution. That's what the Supreme Court judgment said, SC judgment. Okay, so if you want to amend the Constitution, this is the procedure. Okay, there will be a constitutional amendment bill. It can be introduced either by or what is the public member or private member. Public member is the one who is the minister, okay, in the parliament, and the private member is the one who is not the minister, who is from the opposite party or the same party but does not hold any ministry level post. Okay, so either by public member or private member. Let me tell you the difference between constitutional amendment bills and money bills. Okay, so these money bills can be introduced only in Lok Sabha. Constitutional amendment bills can be introduced in both Lok Sabha and Rajya Sabha. These money bills can be introduced only by a constitutional member, I mean public member. This constitutional amendment bill can be introduced both by public and also the private member. And prior approval of the president is required to pass a money bill. I mean, if you want to introduce a money bill, then you need to take the prior permission of the president. And here, prior permission of the president is not required. No prior permission is required. Okay. In the case of deadlock in the sense there are two houses, right? Rajya Sabha and Lok Sabha. If Rajya Sabha passes the bill and Lok Sabha it gets rejected, or alternatively vice versa, then there will be a situation of deadlock. For ordinary bills, the provision of joint sitting is possible. It is Article 108 of the Constitution which deals with the joint sitting, and here no provision for joint sitting. Here for money bills it will be in Lok Sabha only, and Rajya Sabha is given only to discuss, not to pass the bill, but to discuss the bill, whatever passed to the Lok Sabha. Within 14 days, it need to recommend anything, and the recommendations are not mandatory on Lok Sabha. Okay, just recommendatory work it will give in the case of money bills. Okay, and what else I have told you major differences. Let's discuss about the procedure, how we are going to amend the constitution. First, the bill will be passed in the parliament, in Lok Sabha or Rajya Sabha, and each house should pass the bill with a special majority. So these are three types of majorities. Okay, the simple majority and type B majority and type B plus. Type B. One is type B, right? Plus half of the constitution states, like federal provisions, whatever the federal in the sense state matters. Okay, Article 249 and what do you call it, right? 249 and 312. These are the articles related to this have special provisions of Rajya Sabha. Okay, this comes under the federal structure of the constitution. So if you want to amend the federal structure, then half of the states should ratify it. Ratify by simple majority. Okay. So see, amendment is just the change. That change can be brought through simple majority or this special majority. Majorities are again different types. Okay, majority of simple majority, absolute majority, effective majority, and special majority. Again, it is divided into three types: 2/3 of the present and voting. And see, with the help of these majorities, many things will be done. And in those many things, this particular thing, amendment, is one of the procedure. We use this type of majority, type B majority. Okay, 2/3 of the present and voting and absolute majority. And if required to amend the special provisions, then we can take the half of the consents of the states. Okay. So what are all the provisions which can be amended, which can make change to the Indian Constitution by simple majority? So these are all the provisions. Okay, through simple majority we can amend. So this is the Lakshmikant book. Till now I have explained clearly. This is very important. Okay, you cannot find these types of majorities. What is simple, effect, absolute majority? See, using simple majority, we can pass no confidence motion and confidence motion. And this no confidence motion and confidence motion, does it come under this particular thing? What we call amending the constitution. If we pass this no confidence motion, is it the amendment of the constitution? No, right? So simple majority we can use for different purposes. Among the many purposes, one is we can use to amend the constitution also. What are the kinds of the amendments which we use for the simple majority is written in this book clearly. Okay, by simple majority you can attend. Some 18 points are written here. Okay. So admission or establishment of new states, if you want to establish, then you can amend. And formation of the new states and alteration of the areas and boundaries or names of the existing states. If you want to form new states or alter the area or boundaries or names of the states, you can use the simple majority. Simple majority is nothing but half plus one. Whatever there is present and voting. Okay, if there are 30 members present in the parliament and 4 are not voting, then the simple majority will be 26 by 2 plus 1, it is 14. 14 is the simple majority. With the help of this, I am just telling the example. Okay, so if you want to change the name or establish, abolish the existing territories or alter the territories of India, then you can use the special majority, and this comes under the amendment of the constitution. Okay, it is not under Article 368. Article 368 is these two only, type B and this half of the consent of the simple majority. I'm telling you. Okay, quorum of the parliament. So 1/10 is called the quorum of the parliament. This also can be amended using simple majority. And salaries and allowances of the members of the parliament, rules of procedure of the parliament. So this is not called amendment. You are not actually inserting. These rules can be changed with anything. Okay. Privileges. Sorry, these are called the amendments to the constitution. I'm sorry, really sorry. Here, with the help of simple majority, we can amend the constitution. These are all the basic things which we can amend through simple majority. Okay, Citizenship Acquisition Act. This is also, citizenship acquisition or termination comes under simple majority. With the help of simple majority only, you can amend the constitution. Since Citizenship Amendment Act was passed, no, it is the help of simple majority only. Okay. Elections to the parliament and state legislatures, delimitations of the constituencies, union territories, fifth schedule, administration of scheduled area and scheduled tribes, and sixth schedule, administration of tribal areas. Okay, Assam, Meghalaya, Mizoram, Tripura tribal areas. Okay. These are all the things which we can amend with the help of simple majority, with this simple majority. And type B thing of majority, like you need to 2/3 should be present and voting, and absolute majority in the sense, this I will discuss. Okay, so with the help of this type B majority, what we can amend is the provisions of fundamental rights, directive principles of state policy, and all other provisions which are not covered under the first and third categories. First category in the sense simple majority, third category in the sense this half, first one plus half of the consent of the states. So I have told you, right, fundamental rights, DPSP, and all the provisions which are not covered under first and third thing. And the third thing, with the help of half of the consent of the state, we can edit 8 things. Okay. So 8 things are education of the election of the president and its manner, how the president of India is getting elected. So if you want to amend the procedure, then you need to have 2/3 of the members present and voting, and that should be greater than the absolute majority. And also, you need to take half of the consent of the state. Totally 28 states are there. If 28 states are there, then you need to take more than 14 states consent in order to edit this election of president and its manner and the extent of the executive powers of the union, Supreme Court and High Courts also, distribution of legislative powers within the union and the states, goods and service tax. This was not first amendment. Okay, I will tell you the amendments also, recent amendments, what happened from 101 to 105 till now. 105 amendments have been made using Article 368. Okay, representation of states in the parliament. So power of the parliament to amend the constitution and its procedure. So Article 368 itself you can change. So without changing the basic structure, okay, remember this is without changing the basic structure, you can amend the amending power of the constitution itself, and this comes under this particular thing, type B majority, this one. Okay, if you want half of type B plus half of the consent of the states, with the help of half the consent of the states, you can amend the amending power of the constitution itself, which is Article 368. So this is all about this particular procedure, how can we amend. Now let's talk about the types of majorities. Okay, there are actually 4 types of majority: simple majority, and one type it is not, we will not use anywhere there. Okay, so this you can't find in any book. Just listen carefully. Okay, simple majority is the majority of half present and voting. I have told you, right, 30 members are present, 4 are not voting. Then you need to subtract 30 from 4, it is 26, and the majority, more than half, it is 14 members, is the simple majority through which you can amend the constitution or do anything. So the provisions which we can do with the help of simple majority are no confidence motion, adjournment motion. Adjournment motion will be there in the parliamentary devices. Okay, and election of deputy, vote of thanks of the president and governor's address, and ratification of the constitution amendment bills by the states. So here you need to take the assent of the states, right? So if you want to take the assent of the state, then state assemblies should pass with the help of simple majority, this majority. This is special majority, and if you want to take the consent of the state, in each state the legislative assembly should pass with the help of 50% of the votes, simple majority. This is simple majority. Okay, don't get confused. Okay, election of deputy chairman of Rajya Sabha, and he is vice president. Okay, election of speaker of legislative assemblies and state legislative assemblies, and passing of ordinary money bills. So money bills is simple majority. I have told you, right, here money bill is simple majority only. Passing of money bills takes simple majority, and financial bills and ordinary bills, for that all comes under the simple majority. Then we come to absolute majority, 50% of the strength of the house. What is the strength of present strength of Lok Sabha? It is 543. Okay, 543 by 2 plus 1, okay, 272, absolutely. If you get more than 272 votes, there is absolute majority, but it is used nowhere in the Indian constitution. Effective majority, it is used all the then members, if present, voting or not, it is not considered, okay. So here, if we have subtracted the non-voting guys, right, so here we won't subtract this non-voting guys, and it will be 30. If 30 members are present and 4 are not voting, then the effective majority will be 30 by 2 plus 1, it will be 16, okay. So what are all the provisions that we can amend with the help of the effective majority? It is removal of vice president. So with the help of this effective majority, we can remove the vice president, we can remove the speaker and deputy speaker of Lok Sabha, we can also remove the deputy chairman of Rajya Sabha, removal of chairman and deputy chairman of state legislative assemblies. These are all comes under effective majority, okay. Hope you are getting my point. This simple majority by 2 plus 1, who are not voting will subtract. If it is effective absolute majority, total strength divided by 2 plus 1, it will be 272. It is used nowhere in the constitution. If it is effective majority, it will be 30. Whoever, or if you are present, then you are considered under the effective majority. And what are the provisions through which we do this? What are all the things which we do through which we use effective majority? It is like removal of the vice president, who is the chairman of Rajya Sabha, deputy chairman of Rajya Sabha, speaker and deputy speaker of Lok Sabha, speaker and deputy speaker of state legislative assemblies. These are all things. Removal, we use the effective majority. Special majority again is divided into 3 things, okay. First one is 2/3 of the members present and voting. So 2/3 of the members present and voting. Let us consider 300 members are present. Okay, 2/3 of the 300 plus 1, it is 201. If 201 or 201 votes, we get it. 4 are present. If 240 members are present, okay, it will be 2/3 of 240 plus 1, okay, 240 plus 1 in the sense present and voting. Whoever are voting only will consider. If you are not voting, then they will remove it. 240 plus 1, 80 into 2, 160 plus 1, it is 162. 162 will be the 2/3 of the members present and voting. What are all that which we use this special majority? Article 249 and Article 312, okay. So if we want to edit these articles, 249 and 312 are special provisions given to Rajya Sabha over Lok Sabha, okay. If you want to edit anything in this, you need to take special provisions from the Rajya Sabha. Article 312 is about the All India services, okay. AIS, IPS and IFS, which you are going to become in recent. Okay, these are all the services in article. So with the help of this absolute majority, so 2/3 of the members are present and voting, and this should not be less than 272, okay, half of the majority. So for example, 300 members are present, then it will be 201. 201 is less than, is it greater than or less than 272? It is less than 272, so it will not be passive. If 400 persons are present, it will be 277, then also it is not passive. 500 persons are present and voting, and 333 is greater than 272, right? So in this case, it will be passed. So it is said that the provision is passed with the type B majority, which is more 2/3 of the present and voting, and which is more than absolute majority, okay. So minimum it should be 408. If you get 408, then it will be exactly 272. Minimum numbers to pass with the help of type B majority is 408, and 272 will get it, okay. 2 by 3 of 408 plus 1, if we do it, 272. With that we can pass, okay. What are all the things that we can do with the help of type B majority is Article 368 constitutional amendment, okay. I have told you right here, type B majority, this is this type of majority, okay. Article 169, 124, 217 Supreme Court and High Court. So removal of Supreme Court judge and High Court, okay. वो मैं हाथ में तुम्हें खा लो। the Supreme Court judge and High Court judges. It was my dad who was calling from me for the dinner because the time is already 9:32 and I need to complete this and this also before eating it. So I have told them. And Article 124 on 217, removal of High Court judges is 124 and it is 217. Okay, 124 and 217 are the removal of these things. Article 368 I have told you. Article 169 abolition. This is doubtful. Okay, Article 169 also we just amend with the help of this, but here it is like simple majority only we can amend in the Lakshmikant, and in our coaching class it is given that we need this type B type thing of majority in order to do. So the third type C majority is very difficult. 2/3 of the strength of the house. What is 2/3 of the strength of the house? It is 362. If you want only impeachment of the president, if you want to impeach a president, then you need this kind of majority in the parliament. Okay. So these are all the types of majorities through which we can utilize it and do various things, among which this amendment is one thing. Type B majority is amendment. So this kind of stuff, even in Lakshmikant, is very much confusing. I have given you in brief what are all the things going on. Okay, what are the types of majority, and out of which we use that majority in the amendment. So this is very important lecture. If you want it, just revise the lecture, it will be fine. Okay, now we'll go to the basic structure of the constitution. Okay, so there are fundamental rights in part 1, 2, 3. Yeah, in part 3, part 4 it is DPSP, part 4 it is fundamental rights, part 3 is fundamental rights. Okay, whether these fundamental rights can be amended by the parliament with the help of this particular amendment power or not. The question came in Shankari Prasad case. Okay, it was in 1951, whether the constitution, whether the parliament can amend the basic can amend the fundamental rights or not. In this particular case, it was posed to Supreme Court judges. In that, Supreme Court judge says that can amend the fundamental rights, and in Article 13 of the fundamental rights, which says that any law which is inconsistent with the fundamental rights is said to be null and void. Okay, whether so in this case they have ruled that that particular law which is there in Article 13, any law which is there which is inconsistent with the fundamental rights will be null and void. That particular law does not come under the Constitutional Amendment Act. So whatever the Constitutional Amendment Act is there, it does not come under Article 13's law. Okay, all the other laws comes under Article 13. Ordinary laws comes under Article 13, which means that this can be amended. These fundamental rights can be amended. Okay, so they have said that in Shankari Prasad case of 1951, fundamental rights can be amended. Any fundamental right can be amended with the help of constitutional amendment. Okay, I told you, right? With the help of fundamental rights can be amended with this second category of fundamental rights, DPSP, and which are not provided in 2 and the first one, it can be amended with the help of type B. Okay, this is type B, don't get confused. Type B is this. Fine. So in the Shankari Prasad case, they have said that yes, fundamental rights can be amended. Also, the case went in Golaknath case in 1977. The Supreme Court reversed its orders. Like it said that it cannot amend the constitutional, it cannot amend the fundamental rights, saying with the help of Constitutional Amendment Act. If you amend the fundamental rights itself, it is very difficult for the citizen to get the justice. Okay, so it said in Golaknath case, like it cannot amend the fundamental rights with the help of Constitutional Amendment Act, and whatever the act is there in the Constitutional Amendment Act also comes under Article 13 law. I've told you, right? Article 13. 13 is that any law inconsistent with the fundamental rights is said to be null and void. This is what Article 13 says. So that particular law, this Constitutional Amendment Act also comes under law. So if the Supreme Court said like this, and again our constitution, our parliament amended the constitution. The help of 24th Constitutional Amendment Act, they have amended the amending powers of the constitution itself. Okay, amending powers of the constitution comes under type second type, third type measure. Okay, I will change it. This is first, this is second, this is third. Okay, under category 3, the what we call amending powers of the constitution can be amended. So with the help of this particular thing, they have amended, and they have taken out the 24th Constitutional Amendment, saying that Parliament can take away any fundamental right and not a law under Article, and it is not a law under Article 13. Okay, this whatever the Constitutional Amendment Act they have produced, it is not a law under Article 13 and can be taken from anything. Okay, so it can be taken away with the help of amendment. Any fundamental right can be taken away. This was done with the help of 24th Constitutional Amendment. So again in 1971 till 1973 it went on like this. Again in 1973 finally Supreme Court said that okay, it was overruled. Whatever the Constitutional Amendment was in the 24th Constitutional Amendment was overruled and stated that okay, any fundamental right any fundamental right you can amend, but basic structure of the constitution should not be amended. Okay, basic structure should not be amended. Without amending the basic structure, you can do anything. You can amend the fundamental rights. Okay, so in order to nullify this, again 42nd Constitutional Amendment was passed in 1976. Immediately after 3 years, no limitation to amending power. So 42nd Constitutional Amendment was passed during the Indira Gandhi period. She was very much powerful prime ministers till today. Okay, so without the consent of the cabinet minister, so if you want to pass an amendment act, you need to write a letter to the president. So without the consultation, she directly wrote. Okay, so 42nd, no limitation on the amending power and no amendment can be questioned in any court of the law, including fundamental rights. So if you amend the fundamental rights, if you amend anything in the constitution, if you amend even the basic structure, or if you amend the parliament and preamble also, this 42nd amendment inserted 3 words. Okay, socialist, secular and integrity in the preamble itself. So if you amend anything also, it cannot be questioned in any court. This was the constitutional amendment brought by our Indira Gandhi. So again Supreme Court said, Miss Indira Gandhi, just hold on. Whatever you have told that no amendment can be questioned in any court, it is violation of judicial review. And as told, you can amend anything except the basic structure. So this judicial review comes under the basic structure, and you cannot amend, you cannot bring out such law. So and also in from 1976 to 1980, it went on like this only. Anything you can amend, nothing can be questioned. Okay. In 1980, judicial review was made a basic structure of the Indian Constitution. And also in 1981, Varman Rao case also, April 24th, 1973. Whatever the constitutional amendments made after April 24th, 1973, constitutional amendment, whatever they are made after April 24th, 1973, they are under judicial review. So what is the exact basic structure of the constitution? Our Supreme Court did not clarify. With the help of all the cases till now, the basic structure was derived. Okay, what are all the basic structure? What constitutes the basic structure? 20 points they have given. Okay, let me read out. It is there in this book. Okay, Lakshmikant, and it is page number 11.2. So these are all the basic structures: supremacy of the Constitution, sovereign, democratic, and republic nature of the Indian polity, secular character of the Constitution, separation of powers between legislature, the executive and the judiciary. So separation of powers between legislature, executive and judiciary. These are all the 3 pillars of our democracy. Okay. So this comes under the federal character of the Constitution, unity and integrity of the Constitution, welfare state, socio-economic. If you can't change the welfare state. Okay, Article 38 of the DPSP states about the welfare state, I guess. The judicial review, I told you right here, judicial review comes under the basic structure of the Constitution. And freedom and dignity of the individuals, it comes under the basic structure. parliamentary system, rule of law, harmony and balance between fundamental rights and directive principles of equality, free and fair elections, independence of judiciary, limited powers of the parliament to amend the constitution, effective access to justice, effective access to justice is a basic structure of the constitution. Okay, principles underlying fundamental rights, powers of the Supreme Court under Article 32. Article 32 is to issue writs. Okay, Article 136, 141 and 142 powers of the High Courts under Article 226 and 227. These are all constitutes the basic structure of the constitution. Without changing the basic structure of the constitution, and with the help of this Constitutional Amendment Act, you can change anything, you can amend anything. This is all about the basic structure of the constitution and amendment, how our Indian constitution is being amended. And that's it for today. Thanks for being with me. Have a nice day. Take care. Bye.